Okay, today is Thursday, December 13th, 2012, and it's 8:15 in the morning. And me and my wife and I were having breakfast this morning. We were discussing the issues about about what's going on. The first issue we were discussing was the fact that James Williams, the transportation manager in Tracy, California, is responsible for the transportation department. Okay, and the discharge was denied, and he should have put me back to work, as we all know that, because of the fact that he didn't produce any evidence by December 25th or after. He didn't respond within 10 days, 20 days, or 30 days, and he violated the time limits, null and void, final and binding. He didn't prove anything, and he also violated labor law, state law, because he didn't prove his case beyond a reasonable doubt that I was guilty. He didn't produce anything. And two, we discussed the fact that the dispatcher falsified my logs. There's no doubt about that, because we're under the federal government Department of Transportation for 24 hours. We're under their wing. Three, I mentioned that they're in violation of company policy due to the fact that I followed all the regulations that we're instructed to follow, myself and 400 other drivers, to follow DOT regulation. It's under the contract and company policy, which means we're under the federal government for 24 hours. Now, what company policy has to do with the federal government, I have no idea. And why do we have two time clocks? I mean, why are we required to punch in on a data machine in a driver's room when we're already on duty when we report to work according to the federal government, the Department of Transportation Regulation 395.15? Now, we're instructed to follow those, and that's what I did. And I was already on duty, but he's saying whatever he's saying. But in any event, I'm innocent. And the fact that I lost a day's pay in 45 minutes when he altered my logs on the onboard automatic recording device. Okay, so he's working and I'm not. So that's the bottom line. Two, went to Workman's Comp for settlement conference. Okay. Spoke to the judge, told him that they're in conflict of liability. They don't have a right to decide anything. And the fact that I've been denied every benefits, whatever. They denied me and didn't pay me every week or every 2 weeks, period. Okay, end of story. He suggested to them, the reason I'm saying that, because my wife reminded me at breakfast of the fact that Adam Stewart did say that the attorney was on the phone with Safeway. And he asked me how long I could work for. And I had a notice of offer work backed up by a QME report that I took on October 13, 2010, somewhere around there. And he said I could do my customary work. It was attached to the notice of offer of work, good for 1 year, plus they took out 15% because I have a permanent disability. And it was deemed accepted even if I didn't turn it in within 20 days. It was deemed accepted. So they should have put me back to work. I'm on call, waiting for a telegram or a phone call to report to work at 10 o'clock in the morning. Eureka run overnighter, and they owe me for 7 days a week at 14 hours a day because of the fact that the notice of offer of work says that work available. Well, there's work available. According to seniority, I have almost 200 drivers underneath me. Well, so that takes care of that. And the important thing, the point I'm trying to make here is the fact that they're in contempt of court. They're in contempt of court. They were supposed to, he was on the phone with Safeway, and the administrative judge suggested, or whatever he said, however he said it, because I wasn't in the room, told him to put me back to work because he was on the phone with Safeway. And Adam Stewart asked me how long I could work for him. My wife was there as a witness. Now, and they didn't do that. They sent me to the lunchroom and sent me home. My understanding is that they're in contempt of court. James Williams, a transportation manager, distribution center in Tracy, California, is in contempt of court and has been in contempt of court. because he didn't put me back to work like he's supposed to. One on December 17, 2010, and then in 2011 or 2012 when we had a settlement conference. He didn't do it again then, and he didn't do it again when the supervisor of the private insurance, Morales or something like that, sent me a letter to please fill it out and send it in, the notice of offer of work. And I sent it registered mail, and my attorney sent me a letter saying to report to work. I did report to work, and it was denied. And the union said, well, we don't know anything about it. It was also denied. And Mike Sadler was the one. So they're in contempt of court. They denied me to go to work. They're violation of 132A. And they haven't proved anything beyond a reasonable doubt. And they're in violation of state law, labor law. Okay? So they're in violation of the contract, and like I said before, they're in violation of their own company policy for the fact that Mike Sadler posted that thing, the attempt to falsify documents, when it isn't possible, not for myself, not for 400 truck drivers, or anywhere in the United States, period. Those machines were installed, or have the companies installed those machines by the federal government, the Department of Transportation, so that no driver in the United States is able to falsify, that's their intent, to falsify any document or any logs, which is their time card they get paid by, to falsify or anything else, because the onboard automatic recording device is tamper-proof, according to 395.15. So that's my point, okay? So there was no falsification because no driver can. So Mike Sadler violated his own company policy by stating, because you punch in late, and you can't punch in late because you're already on duty. And we don't follow company policy because we're under the federal government for 24 hours a day. We're under their wing. So when we get to work, we're on duty to the federal government. We have to follow all the regulations and rules. So I don't know how they figure that I punched in late on a time clock or a data machine in the driver's room, which is separate from the onboard automatic recording device. And if you look under Regulation 395.15, it doesn't mention one thing about a data machine in the driver's room. It doesn't mention it. All it talks about is the onboard automatic recording device, period, end of story. Now, so I'm stating that Mike Sadler violated his own policy and standards. He didn't follow them. And for him to post that up there, I don't know what to say about that. Other than that, if any driver's been fired because of that document, they were falsely fired. It's not true. They didn't falsify anything. They can't. It's impossible. And they weren't late. It's impossible. Okay? Because that's the regulation, and we're instructed to follow it, and we do. But Mike Sadler didn't follow his own company policy by firing people. Okay? That's not possible. The machine is tamper-proof. You can't falsify anything, not by a time clock that has no time card and doesn't record anything. Okay? It doesn't do anything. Okay? So we're under the DOT or the federal government on the onboard automatic recording device 24 hours a day, and all you got to do is check the regulation and company policy and a union contract. So that being said, he needs to explain why. Why did he post that and when it's not true? To back up my statement, all you have to do is look at the regulation and look at the notice that he put on the board. And he also violated the no attendance policy, no fault attendance policy, company policy, that if you're late or whatever, and I don't know how they figure that, because we're under the DOT for 24 hours, that you get a verbal warning. But if that's what they say, that's what to say. That's fine. But I do agree with the company. If you have a time card and you have to punch in at the driver's room on the time clock. And if you do come in late or something, you should get points and a possibility of getting fired. But if you alter your time card, you should get fired. You should get fired. Now, the dispatcher altered my automatic onboard recording device, the logs, and he didn't get fired. But they do have a rule that the supervisors can change the time or sign the time card that has been changed on the employee. But he doesn't have permission from the Department of Transportation, the federal government, to alter those logs. You can't make a company policy going against Department of Transportation, DOT, and at the same time turn around and say that you're on company policy. It's not possible. Okay? Company policy, you follow company policy. Now you turn around and you say, well, okay, if you punch in late even though you're on duty, you falsified logs. That's not possible. If the federal government says one thing and the company says another thing, who are we going to follow? Well, the company says follow DOT, the federal government. The contract says follow the federal government. Now this guy comes along, Mike Sadler, says, no, you don't follow the federal government. Right? I'm right about this. All you got to do is look at the regulation. You're on duty, tamper-proof, period, end of story. It doesn't say anything about you will follow DOT and company policy. It doesn't say that in the contract, and it doesn't say in the company policy. What it does say, no fault attendance policy. Now, it's true you have to follow what's on the bulletin board. That's fine. But you got to be correct about that. And why the union didn't take a position on that, I don't know. But I'm innocent. And they need to pay me the back pay. That's it. So I have a witness. I have the regulation. I have labor law. And I have contractual procedure. And they didn't complete step 1 and step 2, null and void, final and binding. End of story. They need to put me back to work, which I'm waiting here since December 7, 2010, for a registered mail or a phone call to report to work. That was our discussion at the breakfast table this morning. And I got to say, this is not good. This is a third Christmas. So if anybody needs to be disciplined, I don't know who it is, but it's not me. I'm innocent. So that's up to corporate to decide what's what and who's who in the city zoo, because it's not me. I'm a good driver and I'm a good worker and I'm a good employee. So I'm not going to sit down, lay down, and let them tromp on me. It's not going to happen. And my wife mentioned to me the fact that Adam Stewart said that we were stubborn. She said we. And my wife told him, I didn't hear it. My wife stood up and says he's only standing up for his rights. So now the question comes down, do I have any rights? So, am I allowed to stand up for my rights, which is being denied? I should be working. That guy's working and I'm not. And I'm innocent. And I didn't do anything wrong. And I didn't punch in late on no time clock, because there's no time card for that time clock, and you don't get paid for that time card by that time clock, for the fact that if I run out of hours somewhere and I come in, I don't get paid. It's not even recorded. I haven't been paid in 10 years, as well as 400 other drivers. Who knows how long they've been there, maybe 25 years. They haven't been paid. They haven't been paid the difference in miles, and they haven't been paid the delay. They pay, they don't pay. Okay, that's the driver's room data machine clock. It's got nothing to do with the onboard automatic recording device, which you get paid by the trip sheet, and you got to turn it in order to get paid. If you don't get paid. Now, the data machine in the driver's room is not the case. So I'm innocent. I'm innocent beyond a reasonable doubt. It's got nothing to do with policy. The policy, they violated their own policy. They instruct us to follow the regulation, etc., etc., and that's what I did. Now, me and 400 other drivers do the same thing, and I've been doing it for the last going on 10 years. Now, I don't see where I did anything wrong, and I haven't been corrected in 10 years, and haven't been corrected now. And the end doesn't justify the means. So they need to pay me from December 7, 2010. Beyond a reasonable doubt. There's no doubt about it. I follow company policy. I follow regulation. It's not my fault that Mike Sadler got his wires crossed. He should have never posted that document. And the dispatcher should have never falsified or altered my time on my onboard automatic recording device. That was a no-no. Now, I'm only standing up for my rights. So, if I didn't do anything wrong and I'm innocent, do I have a right to stand up for my rights? And should I be returned to work? According to the contract, I should be returned to work. Because they didn't prove anything, they didn't establish anything, they didn't do anything. In fact, they did everything the opposite. Okay? So, and I stand to be corrected. I do. Okay, you can show me where it says we're not under DOT regulation. We're not under their wing for 24 hours. You need to show me that. Because if you don't, we can't be on two policies at once. God, there's no such thing. I've been driving a truck for 50 years. I ain't never heard of such a thing. So you can't be fired for punching in late when you're already on duty. And they got no right changing the time on my logs because I lost 45 minutes in a day's pay. They don't have no right to do that. Two wrongs don't make a right. So me and my wife discussed that this morning, and that's the end of that. I'm getting carried away because you know how it is when you write about something, you get excited, you know. And that's what I am. I'm getting excited, and I start rattling on, and it's just not fair. I should be working. I had 3 Christmases, and this is another sad Christmas. It's gonna be sad, but we're gonna be happy because we're a family. We're together, so it's not that bad, but it is bad. It is bad, but it's okay. It's okay. We'll have our day in court. So anyway. For the record, James Williams Transportation Manager and Tracy Distribution Center in Tracy, California is in contempt of court. And he is also in violation of 132A because I had a notice of offer of work backed up by a QME report that says I can do my customary duties, and they took 15% off because of my permanent disability. They took the money and didn't complete their agreement by not working me for the 1 year, which I asked to be automatic retirement on my birthday next year. And the personnel department to be informed so that I'll be under the protection of the court until my birthday. That way they won't be kicking me off, putting me back on like they did in 2009 and not pay my pension, my back pay, or anything else. And I had a full duty release to go to work. And that's not a controversy, and that's not an issue at this point, because I'm only bringing it up because I need a court order stating that I should get paid my 14 hours a day, 7 days a week, because of the fact of what happened in 2009. So I'm not asking for back pay for 2009 or the pension benefits or anything else, but I am asking for December 7, 2010 because an injustice occurred. An injustice occurred. And they're in contempt of court, and they're in violation of 132A, and they broke state law, labor law, and they violated the contract, and they violated their own company policy. Now, I don't know for sure about that company policy. I stand to be corrected, but it seems to me that Mike Sadler didn't follow his own standards. So, and James Williams, Transportation Manager, is right along with him. So, it's their responsibility, and we'll let the judge decide that. And I have a witness and documents, so end of story.